Good evening and welcome to LawHelp Australia, where we keep you safe and informed with tips and updates. In recent years, Australian immigration has been tightening the processing of visa applications. We have seen this through the implementation of the Public Interest Criterion 4020, also known as the Fraud Criterion. It applies to almost all visas, and joining us today to outline more is Karyn Anderson from Clothier Anderson Lawyers, Dinesh Weerakkody from Dlegal, and student Vymala Yim. Karyn, can you tell us a little bit more about yourself?
Yes, I'm an accredited immigration law specialist, a lawyer and migration agent, and I've been practising in immigration and refugee law for 18 years now.
Wow. And Vymala, a little bit about your background?
Yes, Emily. I'm Vymala Yim and I'm currently studying postgraduate of migration law and practice.
And Dinesh, what is your experience?
Yes, Emily, I came to Australia in 2000 and started my law degree in the same year and graduated and admitted to the legal practice in 2007, and since then practicing as a migration lawyer.
So to start off the show, Karyn and Dinesh, what are your thoughts on the 4020 generally?
It's a real overreaction, I think, by the government. It's very harsh in its operation. It applies much more broadly perhaps than even Parliament intended, and I think we're now seeing really the lengths to which the department can sometimes go to implement what is really quite a punitive provision.
And Dinesh, your thoughts?
Slightly different view. Karyn was talking about the practical aspect, the implementation, which I agree, but I was happy to see after some time the department was taking a serious look at the fraud, the level of fraud that was going on within the department and in the migration sector. But I totally agree with Karyn, the implementation of it is a completely different thing, so there are issues.
So Karyn, can you tell us what is the criterion all about?
So there are within the migration regulations a whole group of criteria called public interest criteria. They might relate to an applicant's health, their character or their immigration history. And this particular criterion is very long, it's quite technical, as we're discovering through cases that are now coming to the courts that are interpreting the provision. It essentially imposes a 3-year ban on any future visa application to anyone who in the past has applied for a visa using a document that is bogus, and there's a particular definition of that.
Right. Yes, what is that definition?
A bogus document is one that is either counterfeit, has been altered, purports to be in relation to someone but is not in fact in respect of that person.
Right. You've mentioned that it applies to a document. Can it apply to any other information that you give to the department?
So a bogus document must be a document, but the PIC also applies to information. So the information could be false or misleading according to the PIC. And the two different strands to which it applies, false or misleading information, operate a little bit differently. So a bogus document does not need to be relevant to any of the criteria. If it meets the definition, it is automatically one that could result in the imposition of this public interest criterion and therefore a 3-year ban. The false or misleading information must, by its nature, be relevant to the criteria, so there's at least a relevance requirement. Neither of them, however, are required to be purposefully given. They have to be not in the nature of a typographical error, not in the nature of something that is deliberate, but it can be provided by a third party, and often a migration agent or someone who's posing as a migration agent has provided a false or misleading document or information that then results in an applicant being caught by the provision.
And can you give some examples as to what kind of visa applications this criterion applies to?
It applies to almost every visa. The one exception that's notable is a protection visa, but there are very few exceptions.
So people should generally be aware of the criterion, yes, and really not give any false or fraudulent documents anyway.
Yes, and be super careful even with typos, because the problem is that that's really a matter of policy, and so what the department considers to be a mere typographical error could be a much narrower range of information than an applicant might actually be seeking to persuade the department.
Just to add to what Karyn said, we can be, the client or the applicants can be careful, but we've seen instances where the client has gone to a migration agent, and basically that's a fraudster in the society, and the client has got into a scheme where they have produced bogus documents, and unknowingly to the client fraud documents has been submitted on behalf of the client. So you not only have to be careful of what you say and what you do, but who you retain to act as your agent as well. You have to do a thorough search and
always
find
do
out.
checks
Yes.
on people. Right.